Good afternoon, Atulji.
Good afternoon, man.
Good afternoon. Just checking with Suhas ji. Just logging in or not. Just need to log in.
Yeah, he said he'll log in after about 5 minutes or so.
Oh, I guess. Is-
Good afternoon, Aarti.
Good afternoon, sir.
You have the support of the Nas.
Ati, am I audible, Ati?
Yes, ma'am. Ma'am,
No.
please stop recording and make me a co-host, ma'am.
Atulji, you're not audible. No. Am I audible? Yes. I'm just
Yes,
I
yes,
have
you
to
are.
add Suhas ji also as a co-host. Ati, did you finish lunch?
Yes, ma'am. Yes, ma'am.
Welcome, Suhas ji. Good afternoon. No, you're muted.
Ma'am, make me co-host, ma'am.
One
So
second,
that I can stop
Yeah.
recording.
Yeah, good morning, all of you.
Doing.
Good morning, Atulji.
And good evening to us.
Yeah, good afternoon, ma'am.
Good afternoon, Suhas ji. I'm just making
Yeah.
you all
Good
go.
afternoon, Aarti. First time CCC and on behalf of CCC and MSCCC team. CCC is a consultant consortium of the Chennai, which is the Association of the Management System Consultant registered under the Society Act. MSC is also Association of the Management System Consultant, but it is the scope is the pan India. So both these associations are uh, doing the with the working with the objective of the to collaborate with the industry platforms, trade association, chambers of the commerce, management association, apex bodies of the government like QCI, BSI, quasi government organization to contribute to the betterment of the industry initiatives, which in turn will be contribute to the betterment of the society. And as extension part of this, we also do the lot of webinars to for the knowledge disseminate on the various domains for the various standards and the regulations. So that in that context, CCC is organizing a series of webinars since last few years during the month of November. And November month is called as a quality month. So to coincide with the knowledge dissemination regarding the qualities and the other regulations. So this year also we are organized uh, almost 6 sessions prior to this. This is seventh session, uh, and the seventh session is about the data privacy regulations. So overall session objective, if you see the regulations and the standards on data privacy are having wider scope. It is not restricted to any particular industry, which was initially maybe a decade and a half back. The mainly all the software companies and the banks, they were only concentrating on the data protection and the privacy the data. But now, since during this century, what we are having for all the businesses, they are using the data and the information as their backbone for all the decision making and the operation activity. Hence, the protection and the security of all this data is very crucial in running the business, and especially in the highly regulated environment nowadays globally as well as in India because of the data privacy regulation. This becomes very crucial, especially when you have handling the privacy data of any personal. This privacy data might be your client privacy data or your subscriber privacy data or your own employees privacy data. That also needs to be covered under the proper or adequate protection of the data privacy. And most of us in our day-to-day life also experiencing some or other types of the privacy intrusion in our daily life. Just to give an example, we get the calls on our mobile phone regarding the bank loans. That is a very common thing. But it is outcome of that. Definitely, there is some data leakage happen of your privacy data to the some outsider who are not supposed to have that data. Also, we are getting the calls for the kids tuition class admission, especially when the kids are entering the 10th or 12th standard. That is very common spam call that we get. So all these examples are the evidences or the trails of data privacy is not being seriously looked after by the industry or the institution or by the organization who are collecting that privacy data. So in that context, it becomes more relevant and crucial since now in August 2023, Indian government has enacted their own privacy law. That is a data privacy regulation, Data Privacy Data Protection Act 2023. So with this opportunity, through this webinar, we are providing the overview of the requirement of such data privacy regulations, standards, then compliance practices, as well as the third-party certification framework. And in today's session, we are having the 4 topics lined up back to back with the 4 speakers. The first will be the Data Privacy Act. The second will be the GDPR Act. Third one is the Data Privacy Certification. And the fourth one is the Data Privacy Practice Compliance. So that is how we have designed our webinar. So we have with us the speaker for the first session, Mr. Rakesh Maheshwari. I'll just have the brief introduction. So Rakesh Maheshwari is a former government officer having worked for more than 35 years in the Ministry of the Electronics and Information Technology. It is also called as a METI, and he is retired on the VRS as a senior director and the group coordinator for the cyber laws and data governance, presently working as an advisor on the technical policies and the regulatory compliance, mainly in the field of the cyber laws and the data governance. During his tenure in the ministry, he has handled the activities related to the Information Technology Act, even the Data Privacy Protection Act, that is initially it was called as a Personal Data Protection Bill. Then social media regulation, which was enacted couple of years back. Cyber security policies, Aadhaar Act in various capacities, including the group coordinator, cyber law, GC, cyber security, GC for the CERTIN. CERTIN is another initiative of the government to take care of the cyber security incidences, and GC for the Aadhaar card. He was also instrumental in the development of the IT, that is Intermediate Guidelines for the Digital Media Ethics Code Rule 2021, and its subsequent amendments bringing in variety of the intermediary regulations and the social media regulation, as well as online gaming, and also setting up the online grievance appellate committee. He has handled more than 400 cases of all levels representing the government interest, including about 50 cases in the Supreme Court and the 300 cases in the various courts. So today he'll be enlightening us on the data privacy regulation part, on the data privacy regulation, that is DPDP Act 2023. So we welcome you, sir, Mr. Maheshwari. I will hand over to you to take it forward. I'll stop sharing.
So thank you, Suhasji, and thank you, Consultants Consortium and All India Management Consultants Association, for having given me the opportunity to be able to share some of my views, primarily, of course, focusing on the DPDP Act, which, as Mr. Suhasji mentioned, has just been enacted on 11th the presidential assent has been obtained on 11th of August. So very recent, just fresh from the oven, and not yet operational, but is likely to be operational within 6 to 8 months from now. And that's why, in a way, it's one of the most important piece of legislation which we need to focus as of date. So I hope you are able to see the screen.
Yeah,
Yes, Mr. Maheshwar, please go ahead.
So,
you can go ahead.
so quickly, I'll just briefly, touch upon the act. And before I just talk about, just like to see, because in today's time, as Suhasji mentioned, the role of data has really gone up. In fact, across the world, if we look at the total population of around 800 crores, 500 crores plus people have internet, and almost everybody who is on internet is also available on social media, almost 90%. And the same is true with respect to our country also. Around 80 crore connections, around 60 crore people on WhatsApp, 30 plus on YouTube, on Facebook, and similar is the large number on various other social media platforms, online applications, and almost all of them, particularly if you look at from the mobile app perspective, all of them tend to collect a lot of personal data. And it is in this context where the data use is there, data misuse is there, that the Honorable Supreme Court in 2017 declared privacy as a fundamental right. And because most of it happens in the digital world, where the virality is the issue, where the cross-border dissemination is possible, where anyone can post from anywhere at any time and can be consumed, information can be consumed by anyone, that particularly relating to our personal data, which can include physiological data, our height, length, weight, address, name, phone number, our travel history, our sexual preferences, our financial data, our biometrics. So much of it is already available. Maybe we tend to sometimes post it. Maybe we tend to, we have seen various recent cases in the past, particularly when the deep fakes have been used, as to how our own data, our own images, our own imagery can be used against us sometimes. And that's where it is very important that the power to share and power not to share, what not to share on internet, becomes very, very important. I start with some questions to ponder, and just plain reading. Are you aware to the extent of personal data which is being collected and processed in any manner in the entity? In the entity can be in, maybe you can just assume, let's say it's bank, as to how much of personal data, for example, is being dealt. Aadhaar, for example, they have a complete database of almost everybody, except barring children, some percentage of children. Otherwise, that's the kind of information which is available. We had a very recent incident of data breach by ICMR, wherein it is being claimed that maybe around 80 plus crore people's data has been breached. So once again, how this information has been collected and is being used. Have the data breaches happened? And when I say data breaches, I'm primarily talking about unauthorized data being accessed. Even if it has not happened with you, what is the likelihood of leakage or unauthorized access of such personal data, either accidentally or otherwise? And whatever may be, about the past, but when it comes to likelihood, the answer will most likely be yes. So the question therefore will be as to, are you aware as to what processes are in place in the organization to ensure, for example, that such personal data is used only by the authorized personnel, and particularly for the purposes for which data has been collected by them, and what is the organization's mechanism available to prevent, detect, or report such data breaches. So it is in this context, as I said, that privacy being a fundamental right, that the importance of data protection, personal data protection, has grown up. And this is where Government of India has come up with a comprehensive legislation dealing with protection of personal data in the digital form. Why, as I said, in digital form is important? So because it is the ability of the digital content getting viral, getting communicated, getting spread, that the importance of protection of this data becomes important. And when I say digital, it can be digital at the first place or maybe digitized later on. Both ways the law applies. So law is about protection of such personal data in digital or digitized forms. It empowers the citizens, it empowers the digital not to share, with whom to share, and the ability to get to know as to what the organization has got, and ability to maybe seek withdrawal, erasure of this data as and when you want it. As I mentioned, it has been published. Of course, simultaneously, the other goal of this particular act was, because the data in itself is like a commodity, a business commodity. It can do wonders, which is what we are seeing in AI now, AI ML. So parallelly, how do we not only protect the data, but also use this data for the promotion of the Digital India program, for the growth of the digital economy, for the growth of industry. So that means a balancing act between what your rights are and what business demand is. The law has been published on 11th of August, very recent. The law will become operational as and when the dates are notified. And as I mentioned, quite likely next 2 weeks through 3 weeks, the draft rules of this act are likely to go public for public comments. And hopefully after the comments period is over, maybe 1 month, 1.5 months from that period, the rules will also be in place. And whatever date or dates are declared by government for various sections of the law, the law will become operational. Having said this, I'll also like to mention that it's not that so far there is no law in the country. We already have the IT Act, the Information Technology Act, and Section 43 of the Act deals with protection of sensitive personal data. When I say sensitive personal data, it actually included financial data, your sexual preferences, intersex status, biometrics data, and medical data. So today, if you look at any website, today you look at any entity, normally they will all have a privacy policy in place, and that privacy policy has to be as per the present IT Act provisions and the present SPDI rules, the Sensitive Personal Data and Information rules. Of course, once the DPDP Act comes into force, this section of the law as well as the SPDI rule shall be withdrawn. And then it is not just the IT law which is there. There are sector law also. RBI mandates certain data privacy requirements. Aadhaar mandates certain data privacy requirements. SEBI requires in fact, all the regulators for that reason have in some way or other, particularly when it comes to digital data, there is already requirement to that an extent. This law, DPDP Act, has to work in harmony with the other sectoral laws. The law is applicable to all the entities, whether you are a government entity or you are a private entity, unless you have been specifically exempted, and exempted primarily because of national security and other reasons. Otherwise, the law remains applicable to everybody. The law remains applicable to every sector. And therefore, the law becomes important. Compliance to the law becomes important. And why compliance becomes important? Because in case you are found to be non-compliant, there can be penalties going up to 250 crores each instance of non-compliance. So it's not that you have been found non-compliant, there is a penalty. Each time you are found to be non-compliant, there will be penalty. So it business also, it can promote manner also. The choice has to be that, of course, the choice is always with the organization, but practically there is no choice because you have to, because this is a law, While the data principles, the users have been empowered, it is expected that they also behave responsibly, and therefore a very small amount of rupees 10,000 has also been provisioned in the Act in case you happen to be making frivolous kind of complaints and other things. So having said so, I'm just moving a bit into the law. As I did mention as to what is personal law, the next word which is there in the law is about processing. And processing, because it's about protection of whatever I am processing as an organization. So what do we mean by processing? So whatever data I am collecting, personal data I am collecting, whatever personal data I am indexing, restructuring, analyzing, storing, transmitting, disposing, maybe sharing it with others to be able to do whatever they want to do. So let's say, I mean, just Airtel or Vodafone or Jio, if you want to have a SIM, you will have to fill out a CAF form in which you will be providing such personal data. Banks, you want to open an account, you will have to give certain personal data. And the entire life cycle of what the bank is doing will be called as processing. And the entity which is collecting, which is processing with the purpose is called as data fiduciary. The person whose data is being collected is called as data principal. And then there is an entity, for example, for Airtel, or maybe for such ISPs, let's say there can be a call center who may be wanting to explain you the plans, or maybe who may wanting to be taking your complaints to be able to resolve. And therefore, they have been outsourced by Airtel or such ISPs to be able to do something with this data to be able to provide services. They are being called as data processors. And lastly, the data breach: authorized, unauthorized, accidental, or otherwise done in a so hacking is also a hacking is a personal data breach, or unintentional data loss is also a personal data breach. And why, as I time and again I have mentioned, that the importance of the importance of our ability to prevent, our ability to detect is becoming important. And it is expected that as and when, for whatever reasons, if it happens, then the people whose data has been breached must be informed. So that's the right. So for example, Air India last year, when they had problem, they reached out to a good number of people that maybe their data has been breached, maybe your data has been breached. Please change your passwords if you are maybe enrolled in any of the programs. Maybe it is possible that the data at the bank level is breached. It may once again require certain actions to be done. So it's important that the users are informed about. In fact, we know WhatsApp in 2019, it informed about 121 people whose phone potentially might have got Pegasus surveillance tool. Or earlier also, when Cambridge Analytica kind of incident happened, Facebook had approached to more than 1 lakh people. And therefore, it is expected, each time there is a breach, that the people must be informed. And it's not just about informing the people. It's also about informing a specially constituted board, which will be called as Data Protection Board. So Data Protection Board, which will be constituted by the government under the provisions of this act, also needs to be informed. And the Data Protection Board shall carry out an investigation as whether you yourself is a victim. I mean, I'm talking you as a, when I'm referring you means organization as of now. So whether you yourself is a victim, or maybe because you did not take care of the data. So data protection, ensuring protection of data, ensuring confidentiality, integrity, and availability of data, personal data, is the responsibility of the organization. And not only the responsibility, at the first place itself, they have to provide a consent. They have to take a consent from the citizen as to what data are they collecting, what for they are collecting, how long they will be using, and with whom they are sharing. So that means transparency is something which is expected from the law. The law is also expecting you that whatever collection is being done has to be done for a lawful purpose. That means illegal activities are not permitted. So lawful, transparent, fair, the purpose has to be given, and you have to retain the data only as long as necessary or as is required by the extant law. Otherwise, you need to delete the data. That means a lot of obligations have been casted for the data fiduciary, for the organization. And data fiduciary, you can just assume that you are the organization who has got the control on the data. You are the one who has defined the purpose of the data collection. So a lot of obligations have been casted on the data fiduciary. And the law also mentions that you can be a significant data fiduciary, which means a larger one where the full law will apply. You will have to appoint a data protection officer. You have to carry out an independent audit with respect to data. You have to carry out a sort of a risk assessment. And law also protects the smaller organizations, startups, wherein minimum set of obligations have been casted out. So a balance has been made out between the obligations obligations on data fiduciaries of different sizes. From a rights perspective, the law has given the users, the Indian Nagriks, the certain rights which are flowing because privacy is a fundamental right. So right to access the information, you can now onwards, you will be able to seek from a particular company as to what data they have collected about me. You can always seek this. You can ask for correction of data in case they are using, if it is being used in automated processing, you can ask for correction of data. You may ask for erasure of data. You may have any grievance with respect to the data. You may like to nominate. For example, for email, you may like to nominate as to who will be the legal here after you, who will be managing your data. As I mentioned, it also talks about certain responsibility of data principles. So that's there. Data is highly, is highly in the cyber world. It moves. It has to be used. It moves cross-border, and to make it the industry friendly, one, there is no distinction between the sensitive personal information or just personal information or critical personal information, which is how it was done in the earlier attempts. However, parallelly, the government has permitted through this law a smooth flow of this data across the jurisdictions, as long as the obligations of those who have collected the data, who are processing the data, fulfill those obligations. Simultaneously, for example, if RBI has mandated that the data, copy of the data has to be maintained locally, and the same is true by SEBI also, then this law also provides, as I mentioned, it works harmoniously with the other laws, sector law. It also provides that if there is a harsher requirement by any other law, the harsher requirement will prevail. And for smooth governance of the Act, a data protection board is being constituted, and to be able to for a smooth approaching to the board is likely to come. I mean, as far as the law is concerned, it clearly says that the board shall be working in an online mode. So it does talk about the board, how the complaints can be made of either the data breach or non-compliance by the data fiduciary, or the consent not being taken, and the consent also needs to be taken in your own language. So it's not just limited to consent being taken in English, any of the 22 languages, depending upon my choice, depending upon the business of the organization, that the organization will have to give this consent notice and the privacy policy in the choice of my language. There is a provision for appeal, penalties, appeal which can go when through the TD Set and the Supreme Court as of now. And lastly, of course, the already working on the framing of the rules and the date separation. What you need to do, and that's my last slide. Therefore, if you are providing consulting to any organization, or if you are an organization in itself, you need to understand as to what kind of personal data is being processed by you as an organization. And for doing that, for any, we have seen ISO 9000, ISO 27000, ISO 27001. We've seen many systems. In any one of them, you have to first of all carve out as to who are the people going to be, doing it. Responsibility has to be carved out. So responsibility, understanding the business of the organization, understanding the act and the compliance requirements, developing the kind of personal data and the nature of personal data, the details of personal data, why are we collecting, for where exactly it is being stored, how long it is stored, what is the legal requirements, understanding of all those aspects. Whether you are a data fiduciary, whether you are like deciding the purpose of the data, or maybe you are just an outsourced agency. It's, as I mentioned, there can be scenarios when you are just outsourcing to someone, to call center, to maybe payroll processing organization, maybe for IT services management. You are just handing over the personal data for certain purposes to a vendor, data processor. So what's your role as an organization? Understand the contractual requirements. So contracts will also have to be reviewed. A data process impact assessment may have to be carried out. You have to develop the privacy policy. You have to develop a consent notice in the language of the user, in the language of choice of the users. You have to train the stakeholders, and you have to see that the law is effectively implemented. And for some reason, if you have a suspicion, or if you have a reason to believe that the data has been breached, you also need to have a system to inform to the users as well as to the board. And that's it. So thank you very much for I'm ready for certain questions. One or two we can take it up now, and together we will take it up once all my fellow panelists finish their sessions.
I request the participant, if they have any specific query on this, they can raise now. They can post in the chat box or the question answer session. You can post it subsequently also. Sarji, I have one quick question to on this. What will happen to the data security and the privacy related regulation in IT 2008 Act once the Data Privacy DPDP Act is enacted?
Yeah, so privacy and security are different. So from a security perspective, the functions which are being assigned to or are being carried out by NCIPC, and the other provisions relating to the security will continue to be intact. and in place. So certain directions, certain guidelines, everything will be there. The only change which will happen is section 43A of the IT Act, which deals with lawful processing of sensitive personal information and its protection by a body corporate, and the same shall be withdrawn once the law comes into operation. So
that's what the
section
market
43A and the SPDI rules shall be withdrawn. Yes.
Oh, thank you. Thank you.
And
So-
that's the as on today.
Okay. I don't see any specific questions in the chat box on this thing. If at all there are any, then we'll answer it at the end. So thank you very much for your enlightening views and the insight to the DPDP Act in the shorter time. So thanks. And we'll move to the next session. Next session is the global data privacy regulation. Again, it is privacy regulation, but in the global context. So I'll just have the brief introduction of the speaker for this session. So I welcome Major Mr. Bose for delivering the next topic that is on the global data data protection regulations. So Mr. Bose is having around over 35 years of the experience in the diverse professional background, starting with the 11 years tenure in the Indian Army, specialized combat operations, soldier training, and handling the advanced military technology. For the past 25 years, he has transitioned into the private sector, excelling the consulting, auditing, training, and the project management. He's a NDA Khadakwasla Pune graduate. So he's a seasoned auditor with the qualification from the Information Security Management System, IT Service Management, BCMS, that is Business Continuity Management System, Quality Management, Energy Management. He's also empaneled for the various ISO standard as an empaneled auditor with the different certification bodies. The ISO standard covered by him are ISO 20,000, 27,000, 22,301, which is about the business continuity. He is a proficient in the formulating the policies and the implementing the strategies in the information security and the IT service management. He has played the vital role in the securing the orders for the consulting and auditing and the training in the different. So that's what the brief introduction about Mr. Bose. I will hand over the session to the Mr. Bose to take on the global data regulation protection regulation. Yeah, Mr. Bose, you can continue. I'll just stop sharing.
Thank you. Oh, thank you so much, Mr. Suhas. Am I audible?
Yeah, very much.
Is my screen visible?
Yeah, screen visible, but the presentation is not visible.
That's good.
Yeah, now it is.
At the onset, I thank everybody who is organizing, especially the Consultants Consortium of Chennai, Mr. Suhas, for organizing. Thank you so much. Look forward to an interactive input session and discussions on regulations, primarily GDPR, and a little focus on other privacy regulations across the globe. What is personal data? We all were talking about data privacy. We must understand what is personal data. I have a small question. You may be able to respond on chat window. So there was a recent robbery in a shop in your neighborhood, and you are not aware of this. Like every other day, you cycle past that shop. You receive a message from Google informing you that your data will be shared with the police. So you have been cycling, there has been a robbery, and you are not aware of this robbery, but Google has sent you a message that your data will be shared with police. Google has the data, police needs the data. Do you think it's a violation of your privacy? You may put it on the chat window, yes, no, don't know. Just a quick, some people have started putting, so nice of you. A combination of yes and no and some in don't know. Thank you so much, all of you. Now, let me just explain what is happening. This is a real-time scenario that happened. There is this gentleman who was cycling past a place and he's using an app which keeps complete track of his miles on the bike, where he's going, etc. He was issued with something known as a geofence warrant. Anybody who, if the incident happens on the map at the timestamp, police identify that they need to know data about all people in the vicinity for a timestamp. That data is shared with police. Google gives you 7 days, depending on law, to react why or why not your data should or should not be shared. Meaning you are a probable suspect. I will not give the answer yes and no. I will continue and we will realize why it is important. Does Google always? Yes, they do. They do even if your phone is on no Wi-Fi, no SIM card. Please understand, I am not saying aeroplane mode. I am saying no SIM, no Wi-Fi connected. It has been proven that Google tracks your information. When you put it into aeroplane mode, your timeline does not show where you have been, but Google has that information as soon as your phone connects to the network. Till that time, the data is stored in your phone. If you go into Google Maps, go into timeline, put a date and timestamp, you will get the clear location of where all you have been. If you see here on the right-hand screen, this is something that I discuss in most of my sessions. On a particular day, I had flown to UK in the year 2015. I do not have this mobile with me, leave aside the data. But when I go to the timestamp, it also shows every step I have taken, my family photos, which I don't have with me. Is this privacy? We'll come to it as we discuss further. My next question, you wear a fitness band, kind of Fitbit kind of a band, to stay healthy. Do you think insurance company has right to access this data? My request to all of you, yes, no, I am not affected. If you can just please put your comments. Most of you, I don't see a single yes. You will all be seeing the same answers. Everybody is saying no. Seems logical. Yes and no depends on certain requirements. And my aim for your response, thank you. And at the end, Mr. Fernando has also given a response. So many of you have given your response. Really appreciate your acknowledgements. Now, Again, I am not coming with an answer. I move on. Fitbit data for criminal investigation. On the left here, there is a lady by the name Karen who was found murdered in her kitchen, holding a kitchen knife, suggesting she had killed herself. A person was also charged, and when given the data, he said, no, I left this place 15 minutes before after delivering the pizza. But he was found guilty because at the time this person was killed, her Fitbit data showed her heart rate increasing tremendously, then going down to 0. And that timestamp and this person's car location and his location coincided to indicate he was inside the house. He was charged with murder. This gentleman said, a masked intruder killed my wife. I don't know who it is. But correlation of all social media data showed that he was the only person and he was charged for murder. Now, here you are saying that data is being used for a purpose which is enabling law. There was a gentleman who shot down a very costly drone, and he was charged for it. He pleaded not guilty. The judge accepted his pleading because this drone was being used to video record his daughter's sunbathing. Again, privacy being breached. Now, when we are looking at all of these kind of environment, let us understand this particular slide a little better. There are different sources of information. Fitbit data is one information from that murder slide. The person's car location as one information. The person's mobile location as another source of information. There are different information sources. The data can be analyzed. Having analyzed, there is an output data, which may or may not be automated profiling. This output data can be used or misused. When used, it is by generally corporations, employees, government bodies. Misuse generally is with cyber criminals, etc. But misuse can also be from government or corporate bodies. Use or misuse is a perception. You all responded yes or no. It is not our perception. It is what law says. And that is why I was refraining from giving an answer yes or no. It is understanding law which becomes important. The law can be GDPR, General Data Protection Regulation, Australian law, Indian DPDP, US Privacy Act, California Consumer Privacy Act, etc. Number of them. Whatever the law says, an organization has to take forward. The organization delivers business in jurisdictions across the globe. You have to understand the law of the jurisdiction where you deliver. And if you are based out of India, positively DPDP, which Maheshwari sir spoke about before this. All these laws can be implemented with the support of a standard, which our co-speaker, Mr. Junaid, will be speaking about. It is ISO 27701, Privacy Information Management System. This law standard helps you implement different laws, and it has got a correlation to jurisdictions. The privacy laws that are across the globe, we have got in India, we spoke about the Digital Personal Data Protection Law. European Union has got the GDPR, which has been in vogue from 2018, 2016 it was passed. United States does not have a comprehensive national privacy law. They do have a law which has been tabled but not likely to be passed. California has a California Consumer Privacy Act, which is CCPA of 2018, amended with additions subsequently. Looking at California Act, the others have also come out with acts at Colorado, Utah, Virginia this year 2023. Australia has got a Privacy Act of 1998. Singapore has got a Personal Data Protection Act amended in 2020. Middle East also, most of the countries have come up with the act. UAE has got a PDPL, which has been passed in 2021. Today, we are just having an overview. And when I was at this previous slide, I emphasized on the factor that there is data analytics and data being used. Use or misuse depends on law. So when you take it forward in your organizations, you have to be able to understand law against, if you're doing a standard, against the standard also. We will now move on to focus more on GDPR. In GDPR, do note that there are large penalties which are possible. Under certain articles of GDPR, 2% or 10 million euros, whichever is larger, is the maximum penalty. Under certain other articles which are more severe in nature, it is 4% of the global turnover or 20 million euros, whichever is higher. There is a website, enforcementtracker.com, where you can go and filter and look at all the penalties that have been placed. And these penalties can be of huge value at an organization because of certain breach, which is because of certain lapses by organization or individual. You cannot afford these kind of financial penalties. It is best to put safeguards in place, understand law, and implement. Here you're looking at a 27 million euros penalty, and there are much more. So who are the stakeholders in data protection? The stakeholders in a data protection are the entities identified on the screen here. You have got a data subject whose rights are to be protected. A controller controls the data. Controller collects data. Controller is responsible for the consent, which is taken from the data subject. The consent has got a privacy notice. The privacy notice declares the purpose, the time, the data protection, the data processor, third country, all data goes into the consent. The controller may be the processor or there may be a separate processor. The processor and controller are both responsible to the government authority, which is in GDPR known as supervisory authority. They come under the European Data Protection Board. There are also at times third parties who handle data. You end up buying a Samsung phone from a Samsung store. Your phone is not working. You go to a authorized repair center. They are another entity. They now collect more data from you. Where do you stay? How did it happen? Etc. So they are enriching the data. There are disclosures that are made to the third party. They are kind of joint controllers. The law also looks at if data is processed, not transferred, processed in third country. So personal data. What is understanding of personal data? Is IP address PII as per legislation? May I request for your input? Your IP address, will it be PII? Great. Many of you are saying yes. Okay. Shankar, you think it's no? Okay. Shankar, if you can give a response, Mr. Fernando, if you can give a response, is dynamic IP, not static IP, PII? I have just qualified my statement a little more. Is dynamic IP PII? Most will say no. The European Court of Law has ruled dynamic IP can be PII for certain data controllers like ISP providers. Understanding privacy PII becomes very important. Yes, Mr. Shankar, it is allocated by the service provider and therefore is identifiable. Absolutely right. Thank you. Thank you for your response. Really acknowledge it. So if you see here, the name John Smith, John Brown, Arvind Kumar alone may not be personal data. But if that name is with a phone number, a desk telephone number, or any other attribute which can identify a person in combination, it links to a PII. Next, we all stay in large societies, some of us in big cities, where we even don't know the neighbor who is on the same floor. If the police ask you, do you know this person? Can you say no or will you say yes? If there is something and there is identification, you will say, yes, I know this person, he stays here. He or she stays here. Though you may not know the name. Another thing, you go and buy coffee from a coffee shop, CCD. You do a cash purchase, are you identified? No. You do a credit card purchase, are you identified? Yes. You do a cash purchase, but you redeem a coupon, are you identified? Yes. Understanding PII is very critical. IP address I already spoke to you about. You walk into a large supermarket and the Wi-Fi tracker is pushing promotional address to the location that you are. Are you being identified? Yes. What are they picking up? Your IMEI number. But you are identifiable. So the general data protection regulation, Mr. Suhas, I can take a few minutes more.
Yeah, sure, sir.
The general data protection regulation has got, it's a law. Please remember we were talking of 27701, which is a standard, and here we are talking of a law. For a law, you require compliance. Whether you're certified or not certified, you will become accountable. If you have followed processes, if you have implemented system, the penalties in law reduce. And therefore, implementation understanding becomes very critical. The law has got 11 chapters. If you are new to this, chapter 1 to chapter 5 will be very important for you if you need to comply to GDPR. Chapter 1 is on general provisions, 2 is on principles. I will just go through some of them in little detail. We do not have time to go into the GDPR per se. What is important is chapter 3 is about the data subject, all the rights of a data subject. Chapter 4 is what controller and processors have to do. And chapter 5 is third country. They have identified in European Union 13 countries outside the European Union who have got equivalent safeguard laws. India is not part of it. In India, we have data from European Union, Chapter 5 applies for us. We must comply to the safeguards under Chapter 5. So Chapter 1 looks at most important, what is the territorial scope and also definition. Please remember that you must go into the definition of processor and what is processing. It is no more about data in rest or data in motion. Even if you are using a thin client and reaching out to data in European Union, you are a processor. Those are connotations one will have to get into later. Chapter 2 is all about the principles. Article 9 is very important about special category of personal data. European Union special category is different. Ethnic beliefs, sexual orientation, creed, color, caste, trade union beliefs, etc. There are different parameters which is defined in Article 9. Chapter 3 is about rights of a data subject. It is about right to access data, right to rectification, right to be forgotten, restriction, automated processing, erasure, data portability, right to object, etc. So these are the rights of a data subject. Remember, if you are a data controller or a data processor, the law allows a data subject to question, and whatever process you have in place or you don't have, within 30 days, you are bound to respond. So understanding the law would become important if you require to. Chapter 4 deals about controllers and processors. Controller collects data directly from the data subject. So there are different obligations with the controller. One of the most important part is about data protection by design and default. You must at some stage understand what is data anonymization, data pseudonymization, what is the difference between anonymization, pseudonymization, masking, and encryption. There are certain variations. And when you are into privacy, pseudonymization and anonymization are important safeguards. In pseudonymization, reversal of data is possible. In anonymization, reversal is not possible. I am a company in Europe. I have to get my salary processed in Bangalore. If it is pseudonymized, all the PII identifiers are masked. I process the data in Bangalore, send it back, they do a reversal and pay out the salary. So these concepts, these technologies are important, and that is data protection by design, one part of it. Moving on, there is also something very important about data protection impact assessment. This is something akin to risk assessment, but it is different. When all you have to do DPIA is defined in law, automated profiling, large scale of data handling, etc., there are certain parameters. There has to be somebody who is identified as a DPO. They also have got code of conduct and certification schemes. The certification schemes, as of now, is not deliberated totally under law. Next is the chapter 5. If it is transferred to third countries, how it has to be handled. There has to be some adequacy decisions in place, which can be the safeguards or binding corporate rules. Article 46 is what you should understand and read if you are handling data in third country. Moving on, we will look a little bit into only one slide into CCPA, that is the California Consumer Privacy Act. This act also deals with rights, but it is the consumers which are being protected. It is only specific purpose of business and consumer. There is a right to know about personal information and what the business collects, right to delete, right to opt out of sale, non-discrimination, correction of data, disclosure of sensitive personal information. So when we looked at different entities, different stakeholders, whatever be the law or the standard, they have got parallels which you should be able to understand, which will help you understand privacy across the globe. So Privacy Information Management System or 27701, these are the terminologies. A data subject is called as a PII principal. In CCPA, it's known as a consumer. So there is a controller, a PII controller or a PII processor in 27701. GDPR is data controller, data processor. It is privacy impact assessment in PIMS. It is DPIA in GDPR. Understanding that mapping of terminologies will give you much ease in understanding concept is important. I overshot time, apologies for that.
No problem, sir, but it was quite insightful. Any questions from the audience? Audience didn't put any specific questions.
No, they have one question. Somebody is asking, when should DPIA be conducted? I will answer that.
Yeah.
A data protection impact assessment, the article itself gives lot of deliberation and detail. It is both ways, where not to conduct. The ICO, which is the supervisory authority of UK, have given clear guidance. Where to conduct is large scale processing. Volumes have been mentioned. If you are doing automated processing, you have to do DPIA, and there are certain more parameters given in the law. If data is copied from customer for analysis purpose, will it be treated as a breach? Okay, I will take that question quickly. Do you see my screen still?
Yeah.
Okay. Do remember for this particular question, Article 13 and Article 14. Article 13, where it is collected by the controller. Article 14 is when it is not been collected from controller. I collect the data from LinkedIn. I collect the data from any other source. There are still very clear regulations there. What to do you have to inform, etc. What is the difference between DPIA and privacy assessment? 27701 gives you the option to do risk assessment and PIA as one. But if you get into it a little deep, you will understand DPIA is generally done as per the article before the start of processing. Risk assessment is done regularly. Privacy assessment and DPIA is basically the same if you look at the standards. Mr. Suhas, there would be more questions. Shall I keep taking them? Or?
We'll request the audience to be wait for the responses for their additional questions. We'll have the additional question answer session after the conclusion of the fourth session with fourth speaker. Just now we are concluding the second session. So thank you, Mr. Bose. This was very nice, insightful on the wide varieties of the areas on the data privacy regulations. So I hope all the participants must have enjoyed that thing and carried out certain learning from this. So that's conclude the topic number 2. Our next topic is on the data privacy regulation. The speaker for this data privacy regulation is Mr. Junaid Sheikh. I'll just have his brief introduction. I hope my screen is visible.
Yes.
Yeah. So
Yes, it
Mr.
is.
Junaid Sheikh is a head of the PMO Service Center Operations and the Security Consulting in Asia Pacific Control Case International. So Control Case International, he is a head PMO and taking care of the security consulting. Junaid is in his current role, act as a head of the project management office, service center operations, security consultant at the control case for the Asia Pacific region. He has more than 17 years of the rich experience in the information security management, privacy and the technology management. With his expertise in the privacy information management, Junaid specializes in globally recognized standards such as ISO 27000, regulation GDPR, India DPTPA, directives. His proficiency has been instrumental in elevating the privacy and the security measures at the several multinational organizations. Before joining the control case, Junaid has also impactful tenure in the banking sector, that is State Bank of India, insurance sector, that is life insurance, and the age on related. So these are the two section domains which are very crucial for the information security and the data privacy, banking and the insurance. He was also at the control case leads the team of the responsible for managing the complex information security project. He navigates the challenges of the implementation and enhancing the privacy and the information security framework and across the various diverse organizational landscape and in various countries. So this is what the brief introduction of the Junaid. Junaid, we welcome in this webinar series of the data privacy on the occasion of the November
Thank
Quality
you.
Month. So I will hand over the stage to you.
Thank you.
Please
Thank you
have it.
so much, Suhas sir. Thank you everyone for having me here. I'm going to be sharing my screen. Let me know once you see it. Yeah. All right. So thank you again, for having me here. And I thank all my fellow speakers, Mr. Rakesh sir, and Major Saab, Mr. Bose, for setting up the tone for this data privacy topic. Can you hear me?
Yeah, you can.
Yeah. So I really appreciate it. And data privacy is a very interesting theme which is building up in the Asian region. It's not new, actually. It has been there for a very long period of time, especially when the advent of GDPR in 2016 in European Union. In EU, it was very big, and it had put a lot of impact on jobs, impact on the organizations. A lot of organizations started scrambling across, to get themselves assessed for GDPR. So it was a big deal. And now the same thing is what I personally perceive is going to happen in India with the advent and introduction of the DPDPA Act. Yeah. So very significant, as well as, all the small and large organizations in the country, significant fiduciaries, smaller ones, everybody are going to be, they will have to comply to the regulatory framework. Yeah. And what is the best way to comply to the regulatory framework? Yeah, that is what we are going to be seeing here. How to comply to the act, because it's not going to be easy, right? So there are a lot of ifs and buts, but there are definitely certain easy way. Yeah. So first, let's quickly talk about the difference between what is assessment and certification. I want to emphasize this because I want to put more emphasis or weightage on why you should get certified, why all organizations should get themselves audited and certified from external bodies. So assessment is like, perform internal audit, external audit, risk assessment, yeah, all sorts of scanning, penetration testing, vulnerability scans, and get a report out of it. This is called basic assessment. However, in certifications, examples are like, you get yourself certified for ISO 27000, for PCI DSS, for SOC, and all, right? And not just ISO 27001, but as now, since we are talking about privacy, it is also about ISO 27701. Now, in the assessment, all you do is just check the current security posture in your organization, nothing else, right? But in certification, what you get is the trust of the people, the companies around you. You gain that kind of trust, so your customers will start trusting you, your competitors will start fearing you. um if you are a large organization who are catering to another large organization, it will give you a competitive advantage, right? And that competitive advantage comes when you have a printed copy of a certificate, right? And that is exactly why certification is important, right? So I wanted to emphasize on this part before going to and talking about what is the difference between law, regulations, directives, and given by various countries, which we talked about in the previous session by Mr. Bose, and a framework. What is the difference? Okay. So you all know about GDPR, and we will talk about ISO 27000. But let me tell you a very interesting sequence of event, not story, but sequence of event. So in US, privacy law came in 1974, very old. Okay. But that was pretty old. Till 2000, you know, right, in olden days, your phone number, your name, and your address. How many people would have your name, mobile number, or address? Very few, handful of people. Only people around you who you know personally at your workplace, or your family, friends, right? But after 2000, what happened is when e-commerce got introduced, when a lot of products and services came, online products and services came. So to buy each and every product or a service, what you would do, you would go onto the website, you will enter your mobile number, name, and with that, what happened is that all your data started going onto the internet. And now the condition is that everyone's data is floating around the entire world. Yeah. When this was happening, European Union thought that we should protect people's data, right? And that is when in 2016, European Union came with the law, which is the privacy law. Now, this law is basically what it is, the guideline, it is the principle, it is a kind of a directive given to the people or the organization that you should protect your personal data in this way, right? That was the law. But what happened is that how would an organization certify themselves? Because GDPR does not give a certificate. European Union does not give a certificate. Yeah, like Mr. Bose also mentioned in the previous slide. Now, slowly and steadily, you know, third-party organizations have started giving certificates. But in olden days, there were no certificates. So every organization would come and say that we are GDPR compliant, right? And just show an audit certificate. This is how it used to be in 2016. This was a gap. Because I talked about the trust factor, right? How would a person trust you, an organization trust you? You can't just say I'm compliant. You need to have a certificate in your hand. And that is exactly when ISO 27701 was born. The entire, you know, the organization understood this pain area. They introduced in 2019, the first publication of 27,000 came to the world, and they understood the pain, and they said that, okay, we are giving you a framework, we are giving you a list of controls, we are giving you directives, we are giving you everything, we are giving you a platform. We will also allow certain accredited bodies to to get the certifying bodies to certify and audit you, right? So it gives a complete package. So it's a kind of, you know, package, and with 27701 as a barometer, anybody can kind of, you know, very confidently say that you know, we are kind of complying to the privacy privacy platform, privacy you know, kind of context, right? Every organization must be secure with respect to privacy, and that comfort was given by introduction of ISO 27701. Yeah. So this is the basic difference, you know, between the law and ISO 27701. ISO 27 is a framework. It gives you a certificate of trust, right? So what's the difference? Quickly talk about it. Legal. GDPR is mandatory in European Union. Now, European Union is a consortium of 27 odd members, and every organization dealing with personal data, sensitive data, have to comply to the GDPR guidelines, right? However, ISO 27000 is not mandatory, it is voluntary. It only gives you a trust certificate. The scope here in GDPR is that it focuses on personal data, whereas PIMS, we will start calling it as PIMS from here on. PIMS kind of, you know, give you a much broader picture. It not just protects the personal data, but it also protects the infrastructure, the people around the personal data. Yeah. So from a certification perspective, like I said, GDPR does not officially give you any certificate. You can simply do assessment, and there are some third party who can give their own certification. However, ISO will issue you a certificate. Now, requirements. What GDPR gives is, it's a set of principles, it's a set of guidelines, it's a set of measures to protect your personal data. But PIMS is a exhaustive framework. It is a framework to establish, implement, maintain, and improve your privacy posture in the organization. Yeah. Now let's we have spoken about, so I think my header is incorrect, but this talks about the ISO 27701. So like I said earlier, ISO 27701 is a framework, right? It focuses on strong controls and principles. It focuses on maintaining your security posture, right? Now, in the session of Mr. Bose, you saw a lot of privacy laws across the globe, right? So DPDPA has been introduced in India in 2023. Yeah. So China has its own law, which was introduced in 2021. PIPL, Japan has it from a very long point in long time, 2003. South Korea, Malaysia, Philippines, GDPR introduced in 2016. Qatar, Bahrain, Saudi Arabia all have their laws, including US has a very old law, act in 1974. To comply to these law, what you need to do is, first, if you comply yourself or prepare yourself for ISO 27701, you will automatically, to a large extent, cover all these laws, right? So it's, in one shot, you are killing multiple enemies. Yeah. So that's the reason why all large organizations are currently trying to get themselves certified for ISO 27701. Now, who should get certified? So if you're an organization dealing with large quantity of customer data, and here I would like to add, it's not just about customer data, but employee data as well. You also work in an organization, you give a lot of your data, right? Your health data, your past records, all of this information is there with the organization, right? Your PAN card, Aadhaar card, health card, everything is there. These are all sensitive information. These are all private information. Your not just your information, but you give your parents, contact details also, your spouse's contact detail. So every organization should protect the employee data as well. So in privacy, if you are a large organization with customer and employees, you must get yourself certified. Organizations that are critical to country's reputation, like telecom. In India, there are 2-3 major telecom companies, right? And these companies have data of the entire population of the country, right? So these are very significant or critical to the reputation of the country. If they get breached, the country will lose a lot of face in international markets. So these kind of organizations should be identified and should get certified. Companies who serve international clients, and by default they have to comply to international regulations. Companies who want to gain competitive advantage, they want to maintain a brand, and they want to have a good reputation. Company who, now from after COVID 2020, this is more relevant. Companies with that are global in nature and have remote workforce. In these cases, protecting the private data is extremely important. Now, let's talk about certification. Yeah, getting yourself certified for 27701. So the prerequisite here is that, first of all, you should be certified for the base information security management system, which is 27,000. Yeah. Now, why is that? So let's assume that you are trying to protect your customer data and your employee data. Fine, fair enough. But what if your data center itself overall is not secure? What if the place that you are sitting and working is not secure, right? Is it possible that you will be able to ensure that the private data of your customer is secure? No. And that is the reason, first, you should secure your entire information management service systems infrastructure. That is the first thing that you should do. Your data center should be secure, your offices should be secure, your people should know things about information security, basic principles. Your policies should be in place, your procedures should be in place. Once that is there, you will be effectively protecting the personal data as well, right? So that's the first prerequisite. You should get yourself certified for ISO 27,000. Can you get yourself certified for 27,000 and 27,701, which is the privacy framework put together? Yes, you can get yourself. If you have the manpower, if you have the will, if you have the management support, then definitely you can. Yeah. The second prerequisite is the management support. You know, first of all, your management must give you a good budget, so that you have the proper resources to get yourself certified. Number one. Number two, the management, the top leadership should send an instruction to all the leadership or the functional leaders to support you. If that is not done, if your functional department heads are not supporting you, like for example, your HR department is not supporting you, your IT department is not supporting you, your probably sales operations, your call center is not supporting you, then it is not going to be possible for you to get yourself certified. So you have to ask your management to give you support in these areas, right? That's called management support. You also have to have a good understanding of the framework, and you can either have your internal people to do so, or you can hire external experts, like all the people, the panelists on this forum, people you can find outside good reputed organizations. You can hire them to get yourself started with implementing and getting yourself certified. Yeah. Let me check if. All right. So let's talk about the certification process. First thing first, get yourself ready. Hire a professional, or hire somebody internally, hire somebody from external, the professional who understands privacy, who understands information security. Unless and until you do that, things cannot move ahead, right? So hire a professional. Ensure that the partner that you are hiring is experienced, right? They have done in the past the readiness. They have gotten a lot of organizations, small to large organizations, certified, right? Then start implementing the control, perform all the documentation, perform the risk assessment, perform DPDPA, perform the activities of creating data inventory, perform do internal audits, have the privacy policies, privacy notices, all in place, right? The standard operating procedures for your call centers are very important, especially in privacy. You should have all of these in place. So this is where you get yourself ready. Generally for privacy, it takes about 3 to 6 months to prepare yourself. If you have good kind of support from the management, 3 to 6 months is more than enough for privacy. Now, select an accredited certification body. Yeah. So select a good reputable certifying body. So before I proceed further, let me take you to this particular slide. Right. So certifying bodies, what are certifying bodies? So just examples. So control case, like my organization is a certifying body, BSI, TUV, Bureau Vista, or you can find a lot of certifying bodies. You can do a Google search and you can find them. These certifying bodies can audit you and certify you and issue you a certificate, right? These certifying bodies are all accredited by accreditation bodies, right? What are those accreditation bodies? The ones which are listed here. ANAB. Now, ANAB is popular in United States. A lot of organizations in United States ask for certifying bodies to certify them for through ANAB accreditation, right? Similarly, the UK firms would request through accreditation body through UCAS. In India, I think it is NABCB. Yeah. In India, I think there is one more. I fail to remember the name, but NABCB is famous. So all organizations in India who get themselves certified through in ISO are accredited through NABCB. The panelists are free to add more if they remember. All of these accreditation bodies are a member of IAF, and this is what you need to see when you select, right? So you select a certifying body who are reputable, accredited, and a member of IAF, right? This is how you select. Now, ensure that the certifying body that you select have good experience in privacy. and information technology, right? Then the next step is to finalize the audit date. Now, audit is divided into two parts: stage 1 and stage 2. Stage 1 happens that is the first step in the audit. In stage 1, the auditor will look for your documentation preparedness, documentation maturity. In stage 2, which happens exactly 1 month after stage 1, right, the auditor will look for your implementation. Have you implemented the controls properly? Once the stage 2 audit is done, the auditor will issue you a report, audit report. That audit report will have the findings. It will have conformity, non-conformities. It will have observations. The auditor will then ask you, when can you close the gaps? If you can close the gaps within 15 days, the critical gaps within 15 days or 1 month, good enough. After 1 month, then you will get the certificate. If you do not have any non-conformities and if you only have observations, the auditor will issue you the certificate. This is how, and this generally the stage 1, stage 2, and getting the audit report, everything can be roughly around, it can roughly take around 2 to 3 months. Now you'll receive the certificate. That's good enough. But what will you do with the certificate? So you got the certificate for a reason. So you have to advertise yourself. Advertise it on LinkedIn. Email it to your customers, email it to your employees, talk about it to people, go and talk about your certification on various forums, publish the certificate on the website. So a lot of things, the PR activity that you can do once you receive the certificate. Now, once you receive the certificate, you have to maintain it as well. ISO certificate is valid for 3 years, right? Like I mentioned here as well, it is valid for 3 years. But you have to maintain it. So second year, you have to do a small audit. The same accredited certifying body will do surveillance audit, maintenance audit the next year, the second year, right? The same accreditation body will do it for the third year as well. And this is how you maintain 3 years life cycle of your certification. From 4th year onwards, you will have to get yourself recertified, which is start from the step 1. Now, before I move further, a quick introduction to the organization that I represent. We are one of the largest and the leaders in PCIDSS certification. We are authorized QSA through PCI Council for PCIDSS. We certify more than 700 clients in a year. We are into more than 80 odd countries, 50 plus in Asia alone. And we have a lot of services and certifications that we cover. However, I want to specify, since DPDPA is something which is now very close to India, we have converted all the law into implementable controls, right? Especially for the information security officers, the CISOs and the CTOs, they don't understand the law. So we've converted the law into implementable controls. If you, just understand the controls and do what we ask you to do, you are complying to the DPDPA law. And that's the framework that we have controlled. That's the system that we have created. So we do gap assessment and readiness for that same thing. We do ISO 27000, 27701 certification, gap assessment, readiness, documentation. In same thing for GDPR. We do readiness and audits, and a lot of international privacy laws, like for Qatar, Saudi, and other countries as well. We do readiness actions. You can reach me at jsheikh@controlcase.com as well. Now, since I have 5 minutes more, this is probably my second last slide, and I'll just quickly finish it. So, you should first, what are the things that you should do before getting yourself certified? First is you should do gap assessment. Now, what is gap assessment? Gap assessment is where you are and where you want to be, right? The difference between the two is called gap assessment. So my recommendation to you, or everybody, is that you first get a gap report done, right? Use that gap report to get work done from other business functions, right? Leverage the gap report to get work done from business functions like IT, HR, and sales operation, customer service. It's very important. You can do that by converting it into project plan and use it to get the work done. Then you will have to do, documentation. You'll have to create privacy policy, privacy notice, recruitment policy. You will have to do a lot of procedure and policy document. And a lot of things are in large organization. It is already there. It's just about, fine tuning things. If you do not have a data privacy officer, you might consider hiring a data privacy officer. Yeah, you might consider creating a data inventory. Where is what are the kind of personal information, sensitive information that each of your department is handling. Do you know that 99% of the organizations don't even know what kind of personal data they handle, and it's very surprising. We work with so many organizations, so you should create a data inventory as well, and then you should get yourself audited, finally audited. Yeah. Now, quick recap. This is my last slide, but quick recap. So first, certification audit is divided, the final audit is divided into 2 stages, month 1 and month 2. The certification that you get for ISO 27000 and 27701 is valid for 3 years. Prerequisite is that you should get yourself certified for the base information security standard, which is ISO 27001. You should do gap assessment, create a project plan out of the gap assessment, so it becomes easy for you to close all the issues and problems. Get yourself certified, and the last and final thing is advertise yourself. Yeah. That's about it. I think this is my last slide. I tried to squeeze as much as possible in the 10 slides. I can take questions if there is any.
There are a couple of questions which you can answer. Probably the first question is what is the process of getting ISO 27? That is already being explained.
Yeah.
Then if organization is certified for 27701, can everyone declare themselves as a GDPR or DPDPA compliant?
No, ISO 27701 is a framework, and you definitely are certified by it. For GDPR, you will have to get yourself assessed, and there is a difference. Not everything is as it is, right? You will have to do a gap assessment between ISO 27701 and GDPR. Whatever the gaps are, you will have to fulfill it. One simple example is ISO 27701 does not talk about informing the authorities, right? If there is a breach in your organization, informing the authorities, the government officials within 72 hours. GDPR has specifically mentioned about it, but ISO 27701 does not. So in GDPR, you will have to implement that control. Yeah. In GDPR, you have to also, hire a data privacy officer. So there are a lot of small differences, gaps, which you will have to fulfill. Same thing with DPDPA. DPDPA is, in the difference between DPDPA and other laws is that here DPDPA identifies the significant organizations, significant fiduciaries with normal organizations, right? So what are significant fiduciaries or big organizations? Organizations which can impact the sovereignty of our country, right? Which can impact the reputation of the country, right? So that is what DPDPA identifies. So you will have to do a gap assessment and fill in the gap.
There are few more questions, but that we'll take it at the end of the session
Sure.
after completing the 4th topic. So thank you, Junaid. It was a quite informative session. Covered quite a few important points. Thanks a lot.
Thank you.
We'll conclude the session here. Those who are having further more questions on this, they can put up in the chat and the question answer session. Thank you. We'll move to the next topic. Next topic. Next topic is about the data privacy practice compliance perspective. So that means till now we have covered the DPDPA Act, then GDPR, then ISO 27000. What are those regulations, requirement, and how the certification happens. But this is what the next session we are trying to give some insight on the practically what is happening and how the practice of the compliance with respect to the privacy requirement need to be maintained or operationalized. So the speaker for the next topic is Mr. Venki Seshadri. Mr. Venki is a banker with the more than 33 years of the experience covering the large scale banking technologies and the operation. His domain expertise is the spans the global market, global cash operations, anti-money laundering, security services, and the data privacy. He is a sub CWA, CISA, CIPM, and then CIPP. He is currently handling works with the one of the bank that is handling the data privacy. He is the head of that. He is also earlier director of the Flux Bank Group and vice president in the Shanghai Bank. So welcome, Mr. Venki Seshadri. We are looking forward to have your practical hands-on with the privacy compliance practice management. Over to
Yeah,
you.
thanks very much. I'll share my screen now. I
Yeah,
hope
I'll
I'm
stop myself. Yeah,
yeah.
you can share your screen.
Yeah, thank you very much for the kind introduction.
Maybe if you can switch on your video, that will be more impactful.
Yeah, I've already turned it on. Are you able to hear me?
No, no, no. Yeah, we can hear your audio, but there is no video from.
Okay, I'm trying to switch on the video. It says video is on, camera is on. Are you able to see me?
No, no problem. No problem.
Yeah, my apologies. I don't know why it's not working.
No problem.
But I hope you're able to see my screen now.
Yeah, yeah.
Okay, so thanks very much again for the kind introduction. So, this is about practicing compliance with the data privacy regulation, DPD as we know it, right? So, moment. Yeah. So I just thought we'd just do a brief overview of the regulation because some of us may not know what this is about. So if you put it in the form of an equation, data privacy, data protection is equal to information security for personal data plus the rights of data principles plus the obligations of data fiduciary. Now I think you would have already got an idea of who a data principal is somebody who owns their own data or responsible for somebody else's data, is authorized by somebody else for in respect of their data. A data fiduciary is what is typically known as a controller in GDPR. It's a person who determines the purposes and means, meaning the why and how of processing data. Okay. So, um, in terms of the rights of data principles, that's the whole idea of the act to safeguard the rights and provide for the obligations of data fiduciaries. So, what are some of the key rights of data principles? It is to obtain information about what data is being processed, seek correction and erasure of data, nominate someone else to exercise their rights, redress their grievances, and also withdraw consent. So these are the primary rights, right? Why is the regulation itself intended? Like I briefly said, it's just to protect rights of individuals who in turn are enabled to protect their personal data, and also to provide for the need to process such personal data for any lawful purpose. Then the obligations of data fiduciaries, right? So we spoke about information security, but we won't go into that in any detail here. But I think it's already been addressed through 27,001 and other requirements. So we spoke about the rights of data principles. What are the obligations of the data fiduciaries? One is to process the personal data either with consent or other legitimate basis. Second is to ensure the accuracy and completeness of the data. Now, this is a right under law. Earlier, for example, if there are government and non-government organizations also, and the data was not complete, today you have the law backing you up to say that the controller, the data fiduciary, should be able to complete your data, and you can always request that because the law provides for it. It is also to protect your personal data, uh, uh, as a data fiduciary, and it's also to respond to a data principal when they exercise their rights. For example, the exercise of rights could be to seek more information, to know what's happening with the data, or to seek correction or even erasure of the data. There's also the obligation to inform the data protection board in case, and the affected persons in case of a personal breach. The next obligation is to erase personal data as soon as the purpose has been met and retention of the data is not required for any legal purpose. The data fiduciary also should have a proper contract with the processor, meaning anybody else, a vendor, who can end up processing personal data. So this contract needs to be compliant with the law. And finally, there needs to be a mechanism for grievance redressal by any data principal. I'd like to move on to the next topic as to who really requires compliance and needs to appoint a data protection officer. That's a significant data fiduciary. Now, who is an SDF, a significant data fiduciary? It is basically any entity, meaning a particular company or a large institution, or even class of entities. So, for example, they can notify everybody in the banking sector as a significant data fiduciary, right? Now, this is not totally discretionary. It's based on certain criteria. What are the criteria? It's based on the volume of personal data and sensitivity of personal data. Now, so what is the volume or sensitivity that requires an organization or class of organizations to be declared as SDF? That is not yet known. That will be known once the government publishes the rules under which an entity or class of entities can be designated as an SDF. Another criteria is the kind of risk that is caused to the data principals. So, larger the risk, obviously, more the ability for the organization to end up as a significant data fiduciary. At this point in time, based on the conversations by the minister concerned, they're not looking at small and medium kind of organizations. They're really looking at big data processing units that are there in the country, right? So it's those units like, for example, Google or Facebook, WhatsApp, Meta, and those kind of organizations which have very large data sets. It can also be organizations that are catering to the retail market. For example, uh, organizations such as Make My Trip or Big Basket. So, where the volume of data handled is very huge. It can also relate to large scale sectors such as banking, insurance, and so on. So, at this point in time, the focus of the government is let us deliver the largest benefit as per the size of the organizations handling data. So chances are, there'll be a graded, uh, you know, process to target more and more significant data fiduciaries, right? At this point in time, not every organization needs to be bothered about it, but they should be aware that there is a law. They should be aware of their obligations under the law, and watch out for when they can be declared as an SDF. There are other public interest factors which I won't go into detail. So this is the government's capability to, you know, list somebody as an SDF. What are the obligations of a significant data fiduciary over and above that of any organization that's processing personal data? First thing is to appoint a data protection officer. So a data protection officer is somebody who will represent and talk to the Data Protection Board of India, follow their instructions, and communicate it to the organization. They have a lot of responsibilities under the act, right? The second thing is to appoint an auditor who will independently look at the compliance of the organization so far as data protection goes. So what is this audit? What will this auditor do? This auditor will go into what are the requirements of the law, how well are the units of the organization complying with the law, what are any significant risks either to data subjects or to the compliance with the law, right? And the SDF, the organization, should also assess its own risk periodically. What is that period has not yet been defined, and there can be other prescribed measures which the rules under the law can determine. Okay, so we've spoken about the obligations of the data fiduciaries. These obligations are SDF, on top of the obligations for the data fiduciaries. The data fiduciaries themselves are completely obliged under the law, irrespective of whether they are an SDF or not. I just wanted to stress that point. Now, how does an organization respond to the law once they are aware that they are either an SDF, or once the date for which the effective date for the law is announced? Today, the law is in force but not in effect. It will take effect on and from a date that the government will announce. As of now, there has been no announcement as yet, right? But that said, what are some key responsibilities of different layers of management? First of all, the board of the company is primarily charged with the compliance, right? They need to be aware of the regulation. They need to know what are the key actions to take in order to provide resources for the data protection function to start and for it to be maintained. They also may need to approve various policies that an organization needs to come up with in order to demonstrate compliance. And final is the actual need to appoint a data protection officer. Then there are heads of businesses. For example, if you take a retail organization, you know, they would have various departments, some which actually interact with the customers, people who actually collect data, people who resolve queries, right? And people who provide various support and risk management functions, right? So the heads of the business owners would need to seek advice on how do we comply with the law, right? They need to seek this advice from the data protection officer broadly. The second thing is they need to be able to ask for budget, saying that, look, I have these tasks under the law, so I need this kind of budget. I need an expert on data privacy, whom I can work with on top of the DPO, somebody who can look after my unit, or I need a data protection champion who will be able to, stand up for the unit and do all that is necessary. And the last step is to integrate the compliance into day-to-day business practice. For example, an organization may not have the practice of obtaining consent. They may not even have a bit of a contract, when somebody is using, for example, online services, right? So how does the business bring into this day-to-day process the compliance aspects that's required by the law? So that is something the business owner, the heads of businesses should be well aware of. And then there are the people who actually implement the law. So what's required? I think a lot of time has been spent already on gap assessment. I won't go to it in detail, but just to say, if this is what the law requires, make a checklist. Are we complying with this? Yes or no? There may be cases where we are totally non-compliant. There may be cases where we are fully compliant, or cases where we are partially compliant. So what is the gap in that case, and what do we need to do? Who needs to do what in order to remedy the gap? The next step is obviously to design policies which demonstrate compliance with the law, and then close all the gaps that arise in the gap assessment. There also need to be a department specific training plan, because different departments have different responsibilities. Awareness is one thing, training is another thing. So, for example, the front office people really need to be trained much more, because they need to know how to deal with the customer query uh, when they exercise their rights. They need to know how to live the consent requirements in terms of obtaining the consent from the data principals, right? And then obviously the implementers have to ensure the required implementation as per the action plan that's required to uh, deliver the gap assessment. And then comes the real work of continual reviews, monitoring, and reporting. Right. So, how does the responsible person in each department, how do they review? What kind of risk assessments will they voluntarily undertake? Right. And how will they monitor their compliance or the lack of it? How will they surface the gaps? How will they report the gaps? and how will they seek management attention and perhaps even resources in order to meet the requirements of the law. Okay, so what are some key challenges that organizations usually face when confronted with a new law? So I've kept this at a relatively high level. First is to whether to appoint a DPO or not appoint a DPO. Right. So while definitely for an SDF you have to appoint a DPO, in other cases it's not mandatory, right? So that said, there should be somebody at least in I would say large size organizations of 250 plus, at least somebody who's well versed with what the law requires, even though you may not fall under the law. Tomorrow things can change. So it's better to have some person within the organization certified, for example, in CIPPE or something like that, where there's a commonly recognized industry level certification, right? And somebody who can easily interpret the law for you and tell you what needs to be done. So the challenge is the market doesn't as yet have sufficiently skilled staff who are certified and who are capable of coordinating the entire data protection efforts in an organization and who can also respond to the Data Protection Board of India. So what are some possible solutions? I think a lot of certification related thing has already been spoken about. CIPPE is one definite certification where your data privacy champion or data protection officer needs to be certified to as a very minimum until there are established certifications in India. Maybe the rules can provide for certification. And if nothing else, to seek the help of the legal department or a legal expert to say, what are my responsibilities? What do I need to do? The next area is, how do we really create a data protection program? And the challenge is, no one single individual can build this on their own. So they need various stakeholders, and typically a committee is appointed or specific team is set up, project team is set up to take care of this. Large organizations may need a committee just for the budget, getting the business approval, and they may need a separate committee for the implementation. So why we look at two committees? One committee has to determine saying that, look, this is what we need to do in order to comply with the law. Another committee may say, okay, fine, we have received the list of things to do, who should do what? So for very large organizations, typically there's an advisory committee which determines the strategy for adoption by various business units. And there is another implementation committee to say, okay, where are we in terms of our project? What are the milestones? How do we report to the board and so on? Another key area that will require attention is the updation of the terms and conditions of contract and consent, because that will be our fundamental basis for processing data. In most organizations, 95% of the legal basis is either consent or which is taken while at the time of collecting data, or if it actually results in a contract, then the contract has the required terms and conditions. Now, what are some of the challenges that are faced by organizations? Now, how do we get the funding in order to update the terms and conditions? Now, this can be in many places in an organization. So in each touch point, how do we make sure consent is actually taken properly with the proper disclosure of information, with the proper disclosure of their rights, right? So how do we do that? Now, obviously, where a website is being used and data is being collected, then that will need a thorough review to see how the contract, how the consent is captured, how the contracts, if any, are captured, right? So in every principal touch point with the customer, that needs to be engineered to make sure that the required compliance is in place. Now, how do we do this? So obviously we need to seek some legal expertise, and if you have a DPO, then the DPO can do this. You will need the required technology related expertise as well, and you will have to budget in advance. You may not be covered by the SDF requirements today, but if you're large enough an organization, you still want to be prepared so that you upgrade the law. See, the law does not say only SDF has to comply. The law says anybody who's a data fiduciary has to comply. So theoretically, every organization is exposed if they are handling personal data of individuals and do not comply. The next point relates to clarity on the regulations themselves. So while the law is there, we don't as yet have an effective date for the law, right? We don't have the rules in place. And I understand that the Data Protection Board of India is in the process of being set up. So the regulations will come in one by one. And as and when the rules are published, we need to keep updating ourselves. So the applicability and coverage is an area of challenge. And the solution is to keep in touch with the experts on dates and applicability. Now, I just wanted to keep this at a high level and keep more time for questions and answers. So at this point in time, you're welcome to, bring up your questions and answers, please. Thanks very much.
Thanks, Venki. Audience, we are open for your questions, either in the chat box or question answer for this session first. Then we can switch over to the other session. So
Yeah, there's
I'll
one
start
question
with
already.
yeah,
Can I
I will
take that?
start with one
Please.
query. Like there is a significant data fiduciary. Is there any kind of a significant data processor? Because what happens, data processor might be handling small agreements or the contracts from the different agency, but collectively that data processing might be bigger and critical. Whether there is any kind of a significant data processor perspective that can come.
At this point in time, the law does not prescribe, the law does not ask for it, right? But at the same time, it's a very good point. Perhaps there are rules that may be specified under the law. They could contain this saying that in aggregate, the data fiduciaries are not very significant. They can be data processors who end up being significant. I think that's a very good point for lawmakers to perhaps consider. At this point in time, there are no specific requirements.
Maybe I'll also divert this question to Mr. Maheshwari sir, because he has mentioned that within next few weeks there will be draft rules on the data privacy regulation will be coming out. Do you expect anything on this significant data processing rules or the guidelines?
There is no concept of significant data processor. So nothing will come on the significance of data processor. It is, I'll say the processing part, some of the processing of data has been handed over, has been outsourced by the data fiduciary to the data processor. Now, if this data fiduciary is a significant one, it has certain obligations. If it is a small one, it has certain other obligations or lesser obligations. But as far as the relation between data fiduciary and the processor is concerned, the call is being taken by the data fiduciary to offload some of its data, to offload some of its job. Whether it does it of its own, offloads, it continues to remain responsible, and therefore there is no concept of a significant or non-significant, less significant, ordinary data processor. Nothing. No rule will come on this aspect.
That is fine. But what we see, data processor generally, what we have seen in India, data processor handles multiple accounts. So in a single account, that might not be significant, but if that multiple account is cumulatively, that is a significant.
So as was mentioned by my fellow colleagues, first of all, it is a data fiduciary who has entered into a contract. You have offloaded some of your job. Now this data processor may be handling multiple accounts, but it is individually responsible for the protection of data, which has been in a way in fiduciary capacity through a contract handed over to this data processor by the said data fiduciary. It does not really matter whether you deal with 100 or you deal with one. You are accountable to the one who has given you the job. For a specific data set, there is one only and there is only one master. and that's it. So master remains accountable because master has taken data from the public. Master is responsible for this data. Whether the master is doing of its own or is handing over or is outsourcing this job is master's prerogative and master's responsibility.
And that's well understood, sir. Thank you. But still, whether as per the regulation, maybe major data processor might not be applicable,
no,
that
sir.
if there is
No,
no
sir.
significant
sir.
data producer.
No, first of all, data processor itself is just a term just to convey as to how the business will operate, but has no legal responsibility whatsoever in the law. So it does not really matter whether you are significant, non-significant. I mean, it's different in GDPR because Major Bose has come.
Yeah,
is visible.
yeah, Mr.
So,
Bose. Your perspective. You are mute, sir. You need to unmute.
I'm sorry. GDPR looks at it very differently. There is nothing known as a significant controller, but it looks at the data set and requires the DPIA to be done as per the importance of the data. And if you draw a parallel to what Mr. Maheshwari is saying, it is the significance of the data which will decide on what the data processor has to do. If it is automated profiling, then there is a different concept. If there is large volumes of data, then there is. So GDPR takes it in that fashion. And I think that parallel, when it comes here, the processor becomes accountable if the fiduciary is critical.
So, sir, I'll add something to this. Let's understand first what is significant data fiduciary. So the definition of it is that any organization that impacts the country, the sovereignty of the country, the elections of the country, the image, the brand of the country, right? Whether it is controller or processor, it really doesn't matter. I'll give you an example. So there are a lot of banks, right? And all banks have ATMs as well. ATM service providers, there are many ATM service providers, right? So they are not the controllers, they are the processors, but they are significant because they are probably, serving customers' data across the country. So they also come under, DPDPA as significant. They may come under DPDP as significant fiduciary. So it has nothing to do with, definition of controller or processor. Any organization that impacts the country's data is significant.
But this is what you are interpreting from ISO 27770.
No,
correct?
from DPDPA. I'm interpreting it from DPDPA.
Okay.
Yeah. It's clearly mentioned, the definition of significant organization fiduciary is clearly mentioned in DPDPA.
So
I think the thing is that it says significant data fiduciary. So for you to be covered by the word, if you're covered by the definition of a fiduciary, then like you say, any entity will be there. So if you're not a data fiduciary, that was Mr. Maheshwari's point, then you're not covered. That is the simple issue here.
Yeah.
Any further
Okay, there's
questions
one more
this
question
current?
on the size. Can I take that question?
Yeah.
See, the this is from Shankar, and I suppose it's a question for
Yeah,
most.
you can reflash
See,
that.
this thing will be answered only by the rules that will be published under the law, right? So while the law has just given the broad and high level criteria based on volume and sensitivity, right? So there are no specific definitions as yet that are available on who is a significant data fiduciary. Okay, so I'm reading your question as applicable in terms of significance, in terms of being an SDF or not, right? Outside of that, like Mr. Maheshwari correctly mentioned, all organizations are responsible under the law for their data processing. I hope this addresses your question.
Okay.
Yeah. There was one question during my session. Let me answer it. So the question was, for an individual, an employee, what is the list of certification that an individual can look for implementing DPDPA or any privacy law, right? So this was the question. I'm bringing it up on the screen. the list of the certifications that can be looked at. Just give me 1 second.
You need to share the screen.
Yeah, so you can look at becoming a lead implementer in ISO 27000 and 27701. You can look at getting yourself certified for information privacy professional, CIPP or CIPM, or you can look at the DCPLA. So this is the certification DCPLA, if I'm not wrong here. So this is an certification privacy for under privacy issued by Indian body. Yeah, so these are the list of things that you can do as an individual.
Thank you, Junaid. Are there any further questions remain unanswered?
These pertain to the certification, professional certifications of an individual, right?
Yeah.
Yeah,
Just
still we are open to any right now any questions or queries
just
from
like-
the audience.
Yeah, so maybe I'll just like to take up this question from Sachin as to what are the minimum set of obligations for MSMEs.
Yeah.
So from the DPDP Act perspective, there are certain obligations which have been casted for all the data fiduciaries. So they are called as general obligations for a data fiduciary, which include, for example, taking consent for a lawful purpose with clear indication of what is being collected, why it is being collected, and this consent has to be in the choice of the language the user wants, and it can be in English plus any of the 22 languages as per the law as of date. There are other obligations, I'll not go into it, including protection of data of the children and taking consent of children plus parent. But the most important issue is that of protecting the users, protecting the data which has been collected. And as our colleague mentioned, Venki ji mentioned that in case you happen to be a significant data fiduciary, which banks most likely will be, that you will have to have a data protection officer, you will have to carry out DPIA, you will have to carry out independent audits.
Thank you, Mr.
Now,
Maheshwari.
if you are a SME, MSME or SME or a startup, if you are a startup, the law provides lesser obligations, particularly in terms of the consent requirement, as well as certain rights which users can expect. For example, grievance officer. For example, right to be if a user wants to approach as to where all my data has been shared. So certain obligations in respect of certain rights of the users has been reduced in case of MSMEs. But here also, as to who qualify as MSME, because there is no such word as MSME in the law, it is a class of fiduciaries who will be declared as having less onerous obligations, which will also be declared through a notification like the one for a significant data fiduciary. So obligations level are different, and that's it. The law continues to be otherwise applicable.
Thank you, Mr. Maheshwari, for this clarification, because that is what important for most of the class of the industry that is going to be impacted once it is being enforced. There are few queries or the discussion points from me. Whether it will be also applicable for the government administration, right from the center to state to district.
Yes, it is applicable to all. Point number one, it's applicable to all. Point number 2, for the functions which are considered to be lawful, for such functions and for such government organizations or what is called as instrumentality of the state, consent may not be required. Point number 3, certain government organizations, because of their functions relating to national security, they may be exempt completely from the act. There may be certain organizations, they may also be exempted, they will also be exempted from the act completely if they are working in R&D and subject to anonymization practices that they have. And then there is a class of data fiduciary, including government, who will be provided few more exemptions, particularly where there is a court order or there is a disaster or there is a medical emergency. So certain exemptions have been given, but mostly for government, this is what I have explained.
Now I have one query to Jinay. Just take an example, hypothetical example. I want to have a ISO 27701 scope as ensuring the protection of the privacy data in a business operation services XYZ at a location as per ISO 27000 and aligned with the DPDPA. Whether that scope statement will be allowed.
Yeah, sure, no problem at all. Yeah, that is allowed.
Once if we include the DPDPA, our PIMS comply with the DPDPA, whether that will be acceptable by the first by the auditor and then by the CB.
You can have it as a scope. That is not a problem. You can have it. You can put it in your risk assessment, in your compliance matrix.
Yeah, that practice you have to demonstrate. That is
you'll put it. However, the compliance to DPDPA, ISO 27000 itself says that you have to comply to your local law. So you have to demonstrate that you are complying to your local law, and your local law is DPDPA. So in ISO 27701, we will have to demonstrate to the auditor that we are complying to DPDPA. Yeah, there is no other option.
So if same thing will be also applicable for the GDPR, correct?
Yes, in Europe, yes.
Yeah. Then my next question will be to Mr. Maheshwari and Mr. Ghosh. Will be that accepted as a compliance audit report by the authorities, GDPR and DPDP?
Answer number 1, once again, the DPDP code has not come as yet. How exactly it will work will be decided. Point number 2, a breach is a breach. A certification helps one for prevention, for detection, for handling of breaches, and therefore is a reasonable assurance of things being in place. And in any case, when the level of or the amount of penalties will be decided, it will be seen as to what is the due diligence which the organization has carried out. So if the organization is completely unaware, non-willing, then of course the level of penalties will go up. A certification will be very much helpful in placing things in order and hopefully preparing organization, as I mentioned, for prevention, detection, and response, early response. Level of penalties will substantially go down.
Thank you. Mr. Major Ghosh.
Yeah, sir, I need to now exit. I have given my details on the chat box.
No problem. Just 1 minute. Ma'am, would like to have the photo session.
Photo session, and we'll do a poll, quick poll, please. 1 minute. Audience responses. Aarti, can we have the poll, please? The small carrot for all of us, speakers and the organizers. Request all the participants to participate in the poll, please. We request each one of you to participate. It helps us to plan more such knowledge dissemination sessions in the future. As associations, we keep on organizing knowledge dissemination sessions. We don't do commercial programs. As associations, we stay away from commercial programs. and multiple stakeholders are always invited. So this helps us to plan our future sessions also well. Request all of you to participate, please. Yeah, Aarti, can we share the results, please? You all can, oh no, there's another pool. Okay, yeah. You all can scroll down and see, please. Right. Thank you, Aarti. We can stop this. Right, sir? You can go ahead, Suhasji. May I request all the speak. Aarti, can you just unpin Suhasji's? Well, 1 second. Maybe I guess I have done it. Can we have all speakers group pic, please? 1 second. Yeah, yes. Right. Request all speakers to turn on the cameras. Thank you. You can continue, Suhasji.
Yeah, Mr. Bose, you can.
Sorry, apologies. Please continue.
Now you are on mute.
Apologies. We were talking about certifications, and you understand that we did discuss that under Chapter 4 of the GDPR, Article 42 and 43 talks about certification. 42 talks about certification where supervisory authority and accreditation, local accreditation body identifies certification bodies. And Article 43 talks about certification bodies. The advantage of certification is not only that you show a degree of compliance, and therefore, in case of a breach, as I said, the penalty is reduced when you have got levels of compliance. More important under Chapter 5, where you are looking at third countries, and we are looking at safeguards for transfer. Certification is one of the acceptable parameters, which is identified in Article 46. That those are the safeguards for adequacy to take forward transfers. These separate laws actually look at it differently, and I was saying emphasis on the law becomes important. And to what Mr. Junaid said, just to add to it, if we look at 27701, each of the Annex A and Annex B is very specific that you have to identify the jurisdiction before you identify the control. So the controls will vary when you identify jurisdiction.
Thank you, sir. Are there any further questions from the audience? Or we can have the vote of thanks. Yeah, seems to be no more questions. So I thank you all the speakers, Mr. Rakesh Maheshwari sir, Mr. Major Bose sir, Mr. Junaid, and Mr. Venki Seshadri. Thank you being coming on this session for sharing your insightful details on this topic with a short notice. I thank on behalf of the CCC, I thank on behalf of the NSCC, and my personal thanks to also you, because you have been accepted our invitation at a shorter notice. Thanks a lot.
Thank you so much. We'll keep inviting.
Thank you.
Yeah.
Thank you so much. Have a
Thank you.
nice-
We'll keep inviting.
Thank you
Please
all.
do spend some time and efforts to educate the industry and the stakeholders, especially on the DPTP Act. Everything starts with the regulation. We'll keep inviting you. Thank you, Suhasji, for all the efforts
Thank you.
and to
Thank you.
lead this, drive the
Thank you.
conversation. Thank you,
Thank you.
Atulji. Thank you
Bye
so much.
all.
Thank you.
We
Thank
still
you
have
very
2
much.
more
Thank you.
sessions. Request all the audience. You'll keep getting a subsequent reminders. We have a session scheduled for educational services sector, and we also one session on ESG reporting. Request you all to join. Thank you.
Thank you. Bye.
Thank
Thank
you.
you so much.
Thank you, Vijay.
Thank you.
Thank you, ma'am. Thank you, Aarti.